Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Hey everyone, welcome back to another episode of Case Autopsy. This is Mike Campbell, and I'm joined today with guest co-host Chris Finney. Chris, what's going on, brother?
Not much. Looking forward to this one. These guys pulled a huge verdict during this pandemic, and I'm really looking forward to hearing their insights. It's going to be great.
It's a scary thing to try a case, as you well know, and it's even scarier to try a case, I think, during a pandemic.
Yep. Much less get an 8-figure verdict.
Right.
This is going to be some good stuff. Definitely worth sticking around for. Hopefully everybody enjoys.
Yep. Well, let's jump right into it, and let's talk with Greg and Brendan about the good work they did out in Pennsylvania.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Hey, good morning, Brendan, Greg. How are you guys doing this morning?
Good morning.
Awesome. Thanks for having us, Mike.
Hey, could you guys tell us a little bit about your practice and what kind of work you do?
Go for it, Greg.
Well, so we are from Pittsburgh, Pennsylvania. We are in a law firm named Myers, Evans, Lupetin, and Unatin. And our primary focus is medical malpractice cases. I'd say that's probably about 75-80% of what we do. We also do some personal injury as well. Motor vehicle accidents, slip and fall, handle a lot of wrongful death cases, but again, mostly medical malpractice work.
So do you guys have, I know the thing that has spread across the country are medical malpractice caps, and we discussed that a little bit before the show. Do you guys have any type of limitations on recovery in Pennsylvania?
Go ahead, Brendan.
Well, so we're actually pretty fortunate in that regard. I think our state trial bar, trial lawyers association has done a tremendous job. I mean, for a long time now, holding off many attempts to place stringent caps on medical malpractice cases. So we really don't have any caps on pain and suffering like I know you guys do, Mike, in your state. And back in 2003, there was some legislation that was put through that sort of laid out constraints as far as certain things you were legally required to do for filing lawsuits in medical malpractice. For instance, we had to get a certificate of merit before filing, meaning you had to get an expert to essentially bless the case as legitimate and a good case before even filing. Which personally I kind of think is a good thing. It just cuts down on any of the questionable cases. And, I thought that was actually a good piece of legislation, but have not had any caps. The only sort of somewhat financial cap would be on punitive damages. That I believe, Greg, what is it? You can get double. You could basically get, the most you could get on punitives would be double the compensatory verdict amount. But other than that, we're really fortunate not to have them.
So you guys recently tried a case. Was it in Western Pennsylvania?
It's actually Central Pennsylvania.
Central Pennsylvania. Okay.
Technically speaking, yeah.
And so we're not talking about a thriving metropolis of Philly or Pittsburgh. We're talking about in the middle of the state of Pennsylvania, rural area. Is that fair to say?
Yeah, it was rural. It's right outside of Altoona, PA. There's a pretty large Penn State campus in Altoona. But other than that, it's a mostly rural area. It's about 2.5 hours from the city of Pittsburgh. And it's in a little county called Blair County, where we were dealing with. And it's, just a very tight community out there. But as we found, a very passionate community when it comes to justice.
Sure. Now, were you suing a provider and a doctor out there, or who were the defendants in the community?
We actually, so there was 3 initially. We filed, it was a small community hospital where this happened. It was called Tyrone Hospital. And that was actually one of the defense themes was, hey, we're just this little tiny hospital doing the best we can. So we sued the hospital, and we sued a radiologist who was the director of radiology and an emergency physician. However, when we got closer to trial, we realized that the claim against the emergency physician was, it was a very valid claim, but we decided for the best chances of success at trial that it wasn't congruent with our overall theme of the case. And so we dropped the emergency room doctor, which I think Greg and I both felt, if there was going to be any, even though these events, long preceded the pandemic, if there was going to be any sort of halo effect or, glow of frontline providers, it would be the emergency room doctor who would have that. And we just felt it was an unnecessary party, and it was going to probably do more harm than good for our overall trial strategy. So we let him out and just proceeded against the hospital and the radiologist.
And so you have a case against a radiologist. Was this a misread, or what type of case was this?
Go ahead, Greg.
So no, actually, it was not a misread. What happened was our client, Chris, was 41 years old at the time, and he had a history over the last couple of years prior to this of pretty bad back pain with radiculopathy in his lower extremities. So he was ordered to have an outpatient MRI at this small community hospital, Tyrone Hospital. And Chris shows up very early in the morning, and he goes through the initial non-contrast portion of the MRI, about a half hour in length, and he's fine. The MRI technologist, and there was only one technologist who was with Chris at the time, stopped the MRI, went in and started to administer the gadolinium contrast that would be used for the contrast portion of the study. Halfway through the administration of the gadolinium, Chris complains that he's feeling hot. He wants to get up, and he's clearly agitated, so much so that he's moving his arms around, and his butterfly needle, the needle that was used to gain access for the administration of gadolinium, it comes out of his arm. At which point, the MRI tech says, sit down, lay down. She goes back into her control room, activates an alarm, an MRI alarm that was designed to activate in the radiology department and in the emergency department. Shortly after that, moments later, the radiology technologist goes down the hall of the radiology department. She actually had to go through about 3 doors to get outside the MRI suite into the radiology department hallway, and finds the radiologist who is the defendant in the case, and says, hey, I'm having a problem with the patient. I think he's having a contrast reaction. So the radiologist says, fine, goes with the MRI tech through those doors back into the MRI suite. They find the patient again. At this point, the patient is unresponsive. He's described by the radiologist as if he is sleeping and unconscious. The radiologist evaluates the patient for about a few seconds, sees that there's chest rise, but provides no other care at all and no instructions to the MRI tech about care. So now the next thing that happens is the radiologist leaves the patient and the MRI tech alone in the MRI scanner while he walks about 130 feet through the hallways of the hospital into the emergency department and finds the emergency medicine physician. No one has responded to the MRI alarm by this point. But when the radiologist finds the emergency medicine physician, that physician happens to be standing on a chair with his head in the false ceiling. And the doctor, the emergency medicine physician, testified that he was looking for what he described as a very, very faint buzzing sound that he localized to the ceiling. Well, that sound, as it turns out, was the MRI alarm that the tech had activated at the very beginning of this event. So the radiologist, the emergency medicine physician go back to the patient. They find the patient in the same state. The emergency medicine physician, they're still in the MRI scanner, by the way, says he feels for a pulse, finds a pulse, but he can't tell us the nature of the pulse. Okay. They take the patient, they move him out of the MRI suite, down the radiology hallway, into the emergency department, and into a room where they plan to evaluate the patient. A nurse is waiting for him there, and the first thing she finds is that the patient has agonal respirations, a sign of cardiac arrest. They hook up the patient to a cardiac monitor, and he's pulseless. So to answer your question, the long way, that is what happened. It doesn't have anything to do with the interpretation of a study. It has to do with the response to what turned out to be a severe allergic reaction to IV gadolinium. And these violations, as it would turn out, of policies that the hospital actually had in place that should have required a much more timely, prompt reaction and the administration of the drug that was necessary to save this patient's life. As it turns out, he had a cardiac arrest and suffered a severe anoxic brain damage as a result.
And Mike, kind of a gift and a curse of the case was the medical records. And the medical records were very clear and uniform amongst three of the key players at the hospital. You had a nurse who also doubled as the risk manager for the hospital. You had the emergency room doctor, and you had the radiologist, all their medical records. And all their records said that Chris arrested in the MRI. And in fact, the emergency room doctor's note was truly crazy in that he said that the arrest didn't just happen in the MRI, but it was witnessed, and that the patient went for 3 minutes thereafter without any CPR. That was right in his note. However, when Greg and our other partner, Jerry, go and take everybody's depositions across the board, there's a news story, which was, oh no, that's just a reference to the fact that this started in the MRI. But in fact, we got him down to the emergency room and he was basically fine. And then he arrested and we did the best that we could. So you had this diametrically opposite story of the testimony after the fact and depositions after the lawsuit's filed versus what the medical record said. But the reason, your first thought is, oh man, that's a gift. There's a giant sort of lie or something going on in the case. But it made it incredibly difficult to sort of keep track in your mind of what, story are we presenting to the jury about what happened.
Sure.
And so what Greg actually convinced me to do, because at first my knee-jerk reaction was, we're just gonna this whole trial from Jump Street's gonna be about, these medical providers conspired after the fact, to come up with this story because of how bad things happened. And we started thinking like, boy, is right off the bat of the trial, is a jury really gonna go with us that medical providers would do something like that? When they're starting from scratch and they don't know us, they don't know our credibility and vice versa, are we gonna be able to really persuade people at the beginning of that? So Greg said, let's go with their story to start. And we'll show how what they even said after the fact happened was terribly negligent and contributed to this. And so that's what we did. And then sort of over the course of the trial, we started to weave in with each witness, by the way, your medical records actually say something completely different than this. And so then by the very end, we could weave in not so much that we knew which story it was because of how untrustworthy the medical personnel, but what we do know is that there were needless delays in a very time-sensitive emergency situation, and then you just kind of were able to cast that extra, unreliable aspect of the defendant's testimony and basically everything about them that I think, further help things tip the scales in our favor.
And so it's interesting that you brought that up because it sounds like there are a couple of themes that you guys massaged or worked around and thought about that the defense might even bring up, especially in Blair County. How much time did you focus on what the defense might do in a rural county like Blair County versus the offensive strategy that you were going to try to employ?
So first and foremost, especially over the last couple of years, I just have come to believe that it's so important to try your case and to keep your case and the major, winning points of your case, the focus of everything. Every examination comes back to your major themes. In our case, which was, why do you have policies and procedures? Do you expect people to follow policies and procedures? Does that improve patient safety? And if people don't follow them, is that a bad thing? We would always ask that with pretty much every witness across the board, to always keep it focused on the stuff that we knew was our winning points in the case. But you still, of course, have to consider, what are the various defenses that the defense is going to bring or has already voiced throughout the course of it through expert reports or testimony of the defendants. And you have to be prepared to undermine all of that, which we did, but you don't want to spend an unnecessary amount of time on that. And I'll give you a perfect example of where you could go overboard and trap yourself on trying to deal with the defense too much. And again, I give all the credit to Greg on this because he got me off of what would have been a big mistake. So the defendants were trying to forward this idea that all of this happened from the time of Chris's allergic reaction, when he first starts, having something's going on, to his full-blown heart-stopping cardiac arrest in the emergency room. They were trying to say that happened in less than 5 minutes. And actually, by the time of closing, they were trying to say it happened in less than 3 minutes. And Greg and our partner, Jerry, they had literally gone and videotaped how long it takes to walk all throughout the hospital, these different locations where all these different events happened. And, I was sitting there with Greg in preparation for a trial, maybe a couple of weeks out. I'm like, man, we can clearly demonstrate that their timeline is bunk and that it had to be more like 6 minutes or 7 minutes. And Greg was like, why do we want to get into that battle? I mean, saying it was 7 minutes, does that really, change things so much? And it would have been a big mistake if we were then trying to, sponsor the fact that it's important what the time frame was. It wasn't. What's important is violations of policies are never okay, and they clearly delay time. They delayed the time to treatment in this case, and that's what we focused on. And then we would take our pot shots at different times on their timeline, but we never made a big deal about creating our own timeline, which I think would have been a big mistake and would have been the consequence of over-focusing on one of their defenses.
So it's kind of interesting because Chris is a guy who got me really convinced that you got to try your case in teams. You got to try your case with somebody else. And he's a guy who would tell me, don't go that route or reconsider this or don't let me argue this motion. It sounds like that was pretty helpful in your case.
Massively. Greg.
Oh, yeah.
Yeah.
Oh, yeah.
The best teammate is right there.
It's helpful when the guy's right there. Yeah, sure.
Yeah. Brendan is, he's always giving me props and all that, but, I really follow his lead on so many things as well. And I think that's the key. When you have two people, or even more in some cases, who are handling a very complex, stressful case where a lot is on the line, you're going to benefit more. You're going to benefit from the different perspectives that each attorney brings, just the different skills that they have. Brendan excels in cross-examination so much more than I do. And, when we were riffing the night before the big day of trial, where we were going to bring a lot of the defense witnesses on cross-examination, I had to totally rewrite my approach to a cross-examination of the defense witness. Actually, it was the defendant himself, Dr. Biggs, thanks to Brendan's guidance. And then at the same time, I get a call about 11 o'clock, maybe it was 10 o'clock that night from Brendan, right after we had stopped practicing. And he's like, hey, man, can you take over the direct examination of Dr. So-and-so tomorrow, one of our experts? Because, it was just something that Brendan felt that I would excel at a little bit more and do more naturally. So, we always take the approach, and I'm very fortunate for it, that we're not on our own in these cases, and we can lean on each other and benefit from doing this as a team.
Yeah, and I agree with Chris big time that honestly any trial at this point, but certainly any trial of complexity, you have to have a team approach to it. And I think no matter what, it's always better to have, two people trying the case than one. I think the optimal situation is when those two people complement each other really well, which Greg and I really do. And I think that and especially as we've tried more and more cases together, it's like we both know what each other's strong areas are, and are more comfortable just sort of knowing, oh, you're going to handle those witnesses, I'm going to handle these ones. And just, it just helps your understanding from Jump Street and not wasting time, knowing your roles and your jobs in the case, but then also having a partner in the case that is so deeply immersed and knowledgeable of it that you can really riff and get that feedback on different ideas. Whereas other times, if you're just in your head trying the case by yourself, you don't have anybody to really bounce different ideas off that may strike the other person as like, dude, that's a stupid idea. Like, I don't know what, like that, get off of that and get rid of that, where you may have thought it was the greatest thing. And maybe your feelings get hurt at first, but then later you kind of think about it, you're like, no, he's right. That was dumb. And we're going to move on. So just having those kind of sounding boards and going through it together, I think, experiencing something like that together is always awesome too. You have somebody to share that experience and story with after the fact, win or lose. I always love trials because whether you get your teeth kicked in or you win, you always have awesome stories. And it's way better to have somebody else that was right there with you, either add detail to your stories or just, relive it together is way better than doing it by yourself.
Yeah, I was telling our guys, what you were saying makes me think of a friend told me that nothing is as efficient as trust. So if you trust your partner in the trial, you're not spending all this time rehashing this or that. It's like, all right, Greg, Brendan, you take that. I'm cool with it. You can do this tomorrow. Take this. And you don't have to worry about it and sweat it out. And then you also said when you're having those conversations at 10, 11 p.m. at night, you're both equally invested. It's not like you're calling up a friend who's in, Illinois and it's like, hey, I got this cross tomorrow. What do you think? I mean, as much as they want to get involved, they just don't care. And they care, but they can't be where you are. And getting them to your level is not going to happen. And so I think what you said, especially when it comes to a complex case, and I think any case that someone's going to try is a 7-figure case and has some complex issues. So I think we should treat them like that. I mean, is there any point in this case where you thought, oh man, we're wasting our time on this or that? And, it just, talk about those peaks and valleys that go through the case for us. And when you thought, all right, we're all in. When were you like, I'm all in, we're all in on this case, we're going all the way?
Well, we weren't given much of an opportunity. I mean, to my surprise, when Greg, I don't know, I guess it was about a month and a half or 2 months beforehand, and Greg was like, I think this case is going to go, because I hadn't really been involved in it through the litigation. And so Greg was like, I need you, I want you to try this case with me. I'm like, oh, sure. Like, let me get up to speed. And then I read the facts and I was like, holy cow, this is a good case. And so I was like, immediately like, I was thinking, there's no way this case is going to try. It's just too good. They're going to offer something. And then we'd go to these pretrial conferences and they kept telling, the judge, it's a must-try case. And the judge was like, why is it a must-try case? Like, I don't understand that. So basically, as soon as it was confirmed at one of the early pretrial conferences that they're saying it's a must-try case, while you still had that kind of lingering, like, oh, courthouse steps, they'll make the offer. I was like, this case is the best facts that I've ever had to go try a case before. And if it goes, I am lucky to get to go try it with Greg. So the second I read it, I was in.
Did you guys, because we've seen this a little bit more that I've seen on some of the listservs, say, oh, Greg, you handle any negotiations that they have, or did you have roles for that, or was it just jointly together?
There weren't any to have.
Okay,
Yeah.
all right. It didn't even come up. All right, gotcha.
Yeah,
But go ahead, Greg.
No, I was just going to say that, you don't really have a perfect picture of what your trial theory will be like sometimes. I mean, I'm sure there are many attorneys who are much more prepared than I am, who they know right off the bat, when they take the case or they're in discovery that, okay, this is what my case is about. It's not going to change by the time it gets to trial. Well, this was not that type of case. And partly due to us just, having so much to deal with. There were really a lot of mistakes that were made, but we couldn't focus on all the mistakes. And some of the mistakes were just going to go completely beyond the jury, and they wouldn't care about it.
Sure.
And for instance, there was a whole aspect of the case after our client, Chris, he arrived in the emergency department and they found him in cardiac arrest. The resuscitation itself there were a lot of errors in the resuscitation. And there was monitoring that wasn't performed, and there was very limited record keeping about his status during the resuscitation. And so that was a big part of the case, even with the expert reports. But we determined as we were getting ready for trial in the weeks before that this was just too much. It was too much for the jury. It was too much for us to get across with all the witnesses.
Was that based on gut feeling, focus groups? How did you, where did you decide to pare down?
Yeah, I mean, well, focus groups was a big part of it. But it was just a sense that we had such clear systemic policy violations. We needed to focus on that. And that's all we would need to win the case. And for a jury to understand what happened and what caused the harm. Causation was a very big aspect of it as well, because some of those deviations, once the patient already had a cardiac arrest, were once he already had a cardiac arrest. And his chances of survival without severe neurological deficit at that point weren't that great to begin with. We wanted to make the case about preventing the cardiac arrest in the first place, getting to Mr. Miller when he had a severe allergic reaction with a drug that they should have had in the MRI suite at the time, which was epinephrine. As it turns out, they violated this policy that they had in their own hospital to have an emergency drug box, which would contain epinephrine and other drugs to treat a severe allergic reaction to contrast. Any room where contrast was administered had to have that emergency drug box. So, but yeah, it was about preventing the cardiac arrest and not letting him get to the point where he even needed a significant resuscitation.
Were your guys, well, go ahead, Brendan, but I want to ask you about the focus groups though. Did you do, because a lot of people do the in-office focus groups or hotel focus groups. Did you do e-focus groups? Which did you do? Kind of shed some light on that.
Yeah, so I mean, I've been doing focus groups myself for, I don't know, probably 12 years now. I've done many, many, many of them. And but because of the pandemic, we had to pivot to Zoom focus groups, which personally, having done a gazillion in person, I don't think I'll ever do an in-person one again. I love the Zoom focus groups so much that just the control you have, I think you improve your potential demographics of people because you cut down on people having to drive in. They can just do it from their home. And, we'll typically do a 2-hour project and pay people $50 cash. And that might not be interesting to a whole number of people that you'd like to have as potential focus groupers if they have to drive in and get up to your, the conference room in your building or whatnot, versus they can do it from their home. Okay, and then you can just Venmo me money. All right. And then the control that you have during the Zoom focus groups where, as we're doing right now, the box highlights on the person and it kind of almost blocks other people out. So there's less talking over each other. And then you can automatically record it to the cloud at Zoom, and you can pull off the audio if you want to listen to it in the car. It just makes everything so much easier. So honestly, I don't think I'll ever do an in-person one again. That said, that's more of like the nuts and bolts of the focus group. What we did in this case, to the question or the point you made before, Chris, was, it's kind of that funneling effect. The first focus group or two is you put the kitchen sink of facts in there. Of a general overall narrative with kind of everything in there. And you find out what sort of strikes a chord with the focus groupers in that one. And then, Greg and I would talk, and Greg would come back and said, they seem to be gravitating towards this issue did not seem to strike anything, so then we do another one and then focus on different issues. What we did that was unique in this case was after we had done a number of our own what I call qualitative focus groups with anywhere from 4 to 7 to 8 participants, and we had a pretty good idea of what the strong arguments for us were. We actually consulted with a company called Empirical Jury. A guy named John Campbell runs it.
Used them before, yeah.
Yeah, and so we had just by chance heard of it on by Michael Cowan's podcast that he interviewed John Campbell. So I said to Greg, hey, if there was ever a case to do a big, quantitative,
yeah.
got to, we have a potentially huge case here. during a pandemic, medical malpractice in a rural setting where there's really not been any verdicts before. And this is the one to do it. And Greg was like, couldn't agree more. And so we then had them do a big numbers, a big data research project of people in Blair County. And, John came back when it was said and done, and they turned it around in lightning fashion. And he was like, I'm telling you, your fact pattern came back as one of the most overwhelmingly pro plaintiff, ones we've ever had, meaning we had a really strong case.
Yeah.
Which gave us a lot more confidence going into trial, because we really put we put every defense argument that we knew was coming into that fact pattern, and especially against the hospital with the policy violations. We had an overwhelming 94% response on liability in favor of plaintiff going for us.
So Brendan, we're talking about empirical jury, and as we know from personal experience, they give you a ton of data. A lot of data comes from them. It's like a 100-page report, very in-depth, lots of numbers, lots of things, graphs. You got that a few weeks before trial. You'd already been thinking about what you guys were going to do. Where did you guys pivot and say, all right, we're going to totally rely on this. We're going to go with our gut. Where do we make the cuts? How did you utilize it? What'd you do?
Well, I think we were lucky in that it mostly just confirmed that the theories we were going to forward were good ones. And what it also did was it showed us, because, while we were 94%, chance of winning against the hospital, it was 59% against the radiologist, and then 52% against the emergency room doc. So Greg and I then had a call with John Campbell afterwards to, kind of go through what do some of these things mean? What do we have to think about? And we talked a lot about that part of it. Does that mean we should drop both doctors, or what? And John didn't obviously tell us what to do, but the fact that he's practiced as a trial lawyer, he had some really good insights, and he was basically like, look, your theory against the hospital is very in line with the theory against the radiologist, because one of the things that the radiologist had a lot of fault was he was the director of all radiology. So he was supposed to be making sure that the ER people were trained and so on and so forth. Whereas it was much easier for the emergency room doc to either be a victim of circumstance of the policy violations. And then I personally never liked the argument about that he didn't do the resuscitation as well as he should have, or made errors. So I think, we came to the agreement that we're going to keep the radiologist because he goes in line. We don't have to have these totally different, and over in this totally other issue, this also contributed to it. They all went together. And he was also intimately involved in, coming in and seeing our client unconscious and then leaving. So it really just helped us actually pare things down by dropping, encouraging us to drop the emergency room doctor, and then really continue to focus on the theories that we knew were winners based on all of the focus group research.
Now I see, and I'll give it to Mike in a minute, but I see behind you the Who Will Speak for the Victim book by Jim Perdue.
Oh yeah, classic.
Yeah. So in terms of your closings, in what kind of story were you telling? What were you focusing on? What techniques did you use in closing? And did you have anchoring? How did you get to these numbers that you were looking at?
Well, I actually just got the transcript of my closing yesterday, so I could actually send it to you guys if you want to link it in your show notes or something for people to see.
Absolutely.
Yes, thanks.
But I think part of it was, so Greg and I are super, well, we're big fans of everybody, but I really like so much of what Mark Mandel talks about in framing the case,
right.
or case framing strategy, and he has that idea that you don't reveal your overall case frame until closing, for two reasons. One is you don't kind of know how the case is going to come together until closing. And then two, you don't want to really allow the defense to be able to rebut it or start to undermine it ahead of time. So what we sort of thought about was that ultimately it was about, personal responsibility and accountability. There were these gross violations of their own policies and procedures, and, they were refusing to basically even acknowledge them. It just was, it doesn't matter. It doesn't matter at all because we tried real hard and this happened really fast and we did the best we could. We're a small hospital. And so that was the overall case frame that I, probably didn't even unveil as well as I could have in closing, but that was what I was trying to demonstrate. But, personally, I'm always trying to, every time I try a case, I always want to do a few new things, to find out if they work or there's something that kind of resonated with me and I feel like it fits this case. So I've been watching tons of Courtroom Viewing Network over the past year. We got the full subscription, and I just like nerd out on all the videos. And
Absolutely.
I really dig the closing format that Joe Fried and Mike Goldberg use, which is, it's basically 3 parts. The first thing is you stand up and you immediately annihilate all of the bad stuff that the defense just said. Okay, there's no like wasting time with a set thing. First is you just go down the line and blow up everything that they just said of any consequence during their closing. And then you transition to that trials are about 2 things in the United States. They're about truth and they're about justice. And so then your truth component is organized all of your different liability and causation arguments, basically. And then you transition into justice, and then you can work in lots of those different models like Keith Mitnick and Rowley talk about how, you can tie in the Constitution and our constitutional right and that we're a civil justice system into, we're not barbaric. And that's why at the end of the day, because we're civil and our Constitution is so great, it's what our whole country is based on. That's why this boils down to money for the fair trade value to make up what was taken, what was lost as a consequence of, these overt errors, and then a refusal to accept personal responsibility. And then you can just work in whatever damage models or damage arguments you like at the end. So we can't ask for non-economic damages. Like we can't suggest a number in Pennsylvania.
Gotcha.
And I think, again, Greg and I are thrilled with the verdict. However, we had very large economic losses. We had, 6.5 future life care plan, $1.5 million in earnings losses. And I think we tried to weave into the trial an anchor for the non-economics, but I don't think that it worked because the economics were so high. And so ultimately the economic losses were much larger than the award for the non-economics, which I think all total past and future was 2.9 or 3 million. And again, we're not crying about that. It's amazing, but it's just interesting. I think that had we been able to specifically ask for or tell the jury why we thought the non-economics were much larger, and believe me, we tried that in closing. I did the iceberg picture, the non-economics are so much greater than the economics, but I just think that the economic component is what they cared about. They wanted to make sure that this gentleman and his family were taken care of, and then the loss of life pleasures and stuff was a sort of a secondary thought for them. Greg, what did you think about that? Why the jury did what they did?
I think the defendants actually calculated on the jury not being particularly generous with pain and suffering and non-economic damages. Not because Mr. Miller, our client, hasn't suffered and will suffer immensely. He's lost so much. He's like a child now because of his brain injury, and people have to watch over him 24/7. But just because it's a conservative jurisdiction. And I think the largest jury verdict in that jurisdiction prior to ours was like 15, 20 years ago, and it was $4.5 million.
Ironically, that was actually our partner, Jerry, got that verdict.
No kidding.
In a birth injury case, right.
Yeah.
No kidding.
So, I think that as much as Brendan tried valiantly to justify and to convince the jury to do something really remarkable in terms of non-economic damages, it's just not in their DNA in that jurisdiction.
And there's so many things I want to talk to you guys about before we leave this, because you mentioned speed trial. Did you guys, and Mike and I have been looking a lot about this, about speed trial and these experts who come in as they're the second opinion guys. Did you have people like that you called second opinion experts, or what were you doing with all that?
So Greg and I definitely, were committed at the outset. I've been for some time obsessed with trying to make my trials as short as possible. And
Yep.
And that's because a lot of great trial lawyers have been talking about that a long time. I mean,
Yep.
Don Keenan wrote about it on The Reptile like 10 years ago about the
Yeah.
importance of trying a short, concise, and there's a
It's done in a
gazillion
week.
different reasons.
Yeah.
And then more and more people are talking about it. And then it dawned on me, I do all these focus groups. I present a case to a jury in an hour and they get it.
Right.
And
That's a
they
great
come
point.
back,
It's a
and
great
they're
point,
very
Brendan.
often very closely in line with ultimately what happens at trial. I'm like, if I can tell this whole case to a jury or a potential jury in 45 minutes, why do I have to take a week to do it if I can avoid it?
What a great point. Yeah.
So, but Chris, to your point, I listened to, and actually right when the pandemic was hitting, I made a decision. I was about to fly down to Orlando for the first trial school seminar about speed trial that Freed was putting on through trial school. And Florida started to pop up with cases. I was like, and I canceled it. And I was really disappointed because I wanted to go so bad. Thank God they, replayed it virtually a month or so later. We didn't do the full-blown version, so we didn't have time, first of all, to get those secondary ones. And I don't think it was the kind of case that would have lent itself to it. However, Greg and I definitely applied, that basic concept of, what's your name, what's your role in the case, and not wasting time with a lot of background or, the expert's credentials, et cetera, just getting to the point. And we did 17 witnesses that included 6 experts and 2 opening statements. Our case in chief was done in 2.5 days.
Oh, wow.
So
Nice work.
Yeah. And that's because both of us were committed to it. Both of our exams of everybody were just shortened to the point.
Were you guys telling the jurors throughout you were going to respect their time and give them the information they needed and follow through on it? So you set that up throughout?
Yeah. At the end of my opening, that's what I said to them is like, look, we appreciate your sacrifice, everything. I can't promise it, and there are some things that we have to do because we have a job to prove our case to you, but Greg and I are going to do everything in our power to get this case to you as fast as possible, with the information you need to do your job, because you've got other important things to do. And none of us want to be in this room any longer than we have to under the given circumstances, et cetera. So try to set, which I think, I like doing that because I think it kind of capitalized a little bit on that, the psychological principle of reciprocity. It's like, at least we can't give the jury much, but at least we can give them their time back.
Sure.
And we want to be the ones that kind of, grab that mantle and, look, we're trying for you. We don't want you to be here any longer than you have to, kind of thing, and signal that to them.
So it's kind of interesting because you're, the one thing I keep thinking of is when you get a word count and you're looking at your essay and you're thinking, I remember back in college and you're thinking, I can't really lose that sentence or this sentence.
Yeah, right.
Are there certain things that you're like, I can't take a scalpel to that, and Greg's jumping in saying, we really need to cut that, or vice versa? How is that? Was that nerve wracking to you, or was it? Because some of those things feel like a safety blanket, a security blanket to me, to get all that stuff into evidence. To take it out makes me a little nervous.
Greg, what did you think on that? Did we have to do that at all?
Yeah, I think to a certain extent, yeah, by all means, as we were practicing our examinations, we had to go through and chop some things out. But again, just going through the process of getting the trial theories down to the core, the violation of the policies,
sure,
that made it a lot easier for us just to focus on the really important points, the stuff that the jury would be able to digest based on like a 4th grade education or less, really. And Brendan's really good too about cutting things down and revising his opening and closing. And he could tell you more about that process.
And when you say the 4th grade education, it's not like you're talking down to the jurors, but they got to digest information in a really short period of time with pretty complex issues. So we say 6th grade level. I think Mike and I have talked about 6th grade level, which is, we're not taking a bunch of notes here. We're able to take what's coming in and then, then apply it to the law. Is that kind of the idea you guys were shooting for, is let's really boil it down?
Definitely. And Chris, I can actually tell you that I have 3 boys, 9, 6, and 4. And my 9-year-old he's very smart, much smarter than his dad. And, but he's still 9 years old. And I gave him the opening. I sat on my back porch one day in the summer, and he's got the little kid's dry erase board. and I was just using it to draw pictures of the hospital and some of the rules. And he totally got it. He's like, why didn't they do what they were supposed to, basically?
Right.
Like he understood it. He got it. So that made me feel like, okay, we're getting to a point where this is very digestible. Now, had we continued to focus on, all the deficiencies in the resuscitation,
that
is going to be much more difficult to explain easily and quickly to people.
And later in time too, as to where your negligence occurred. It's like, when's the first time? Yeah.
Right. And the other thing, and this ties back to the point about the teamwork component of it, I found personally, so Greg and I were, every night we were role playing our different exams. So if I'm going to do the cross exam with the MRI technician or the radio or the emergency room doctor, then Greg, puts his, hat on and he's that person. And is basically just being as difficult of that witness as he can be in my thing. And then, but what it forces you to do is you realize, oh, I didn't need, 12 questions to get to this point. I can get to that point in 3. Or I realize, oh, that whole little chapter of my exam is garbage. I'm just not even going to do that. It stalls things out. It gets me in all kinds of trouble with them. And I would do the same thing to Greg. Greg did the radiologist defendant, and I played him, and I was a much more difficult. We found that pretty much across the board, that we were way tougher witnesses in the role playing than the real witnesses at trial turned out to be.
That's great.
And that helped you cut down and streamline your overall exams significantly, having done that over and over again.
So when kind of going in reverse through the trial, when you're doing the jury selection, who's doing the jury selection, and what type of, strategy are you trying to use in jury selection? Are you looking to build a coalition? Are you looking to identify those people who aren't the best suited? I hate to divide it into 2 camps like that. I'm just not sure how to blend it correctly. Maybe you can for me.
Greg, why don't you explain what it was like?
Well, I think with jury selection, a lot of the hard work was actually completed before we got into the courtroom. And Brendan took the laboring oar on this, going through the jury questionnaires. We had the opportunity to review the jury questionnaires that were completed by the panel members before they were even called to the courthouse.
Is that, I don't want to cut you off, Greg, but is that a COVID introduction, a request you made to the court, or is that standard operating procedure for that court?
I think it was pretty much standard operating procedure. We were allowed to go to the courthouse about 3 days before trial and go through a stack of maybe 120, 140 questionnaires that had been completed.
You couldn't add to the questionnaires. It was what the court had already sent out. You didn't get to fashion any, did you?
No, we did not. You're right. It's the standard. It was actually also on the issue of COVID. It was a pre-COVID type of questionnaire as well. We had looked into the possibility that they would add some questions or send out even a separate questionnaire just about COVID questions. But that wasn't in there. It wasn't in the initial questionnaire. But as it turns out, it wasn't a big deal. But Brendan did a lot of the legwork, as did one of our associates, and just going through all those questionnaires, trying to get a profile for each individual member of the panel to see, where they sit politically, what are their interests, and then what are their demographics. And Brendan especially had an idea going in of the type of juror that we were most comfortable with and who we felt we could speak to and we would just jive with in terms of personalities. And that would also compose a compassionate jury. And we were looking for a lot of ladies on the jury as well.
Was that info you got from John Campbell that they were responding better and you implemented it that way, or was that just what you guys had found on your own or gut feeling?
My default favorite juror is, middle-aged to older women. I don't know why. I just feel the most comfortable speaking to them. And
they got some experience. They know, they've been through a lot, but they're still hopefully warm.
Yeah. And I was basically kind of raised by my mom, and I have 3 sisters. I don't have brothers. So
I was going to start digging in there, Brendan. I'm the same way. I have 3 sisters raised by my mom, and I'm like, yeah, we could probably do a whole podcast on that.
I think big time. I think about that a lot, Mike. And
oh yeah.
I honestly, I never feel comfortable. Like Greg and I tried a med mal a couple of years ago, and it was a really, really tough case to begin with. And just by luck of the draw, we get in there, and it is like 12 like young guys with beards. I was like, this is not the group that I want to try to talk to.
It's funny because I started going to therapy about 10 years ago. And one of the things that the therapist asked me, why are you coming into therapy? And I said, well, Rick Friedman told me that I should be a better trial lawyer, or I could be a better trial lawyer if I went to therapy. And then I was like, but see, here's the thing. I don't want to see a family member I don't like and a potential juror and then exclude, just like that deep sort of unwinding what's going on in my brain and my approach.
I'm a huge disciple of Friedman, and I've, throughout the course of, last 20 years, I've been off and on in therapy. And I think it's great to find that stuff out about yourself. And again, I've always felt more comfortable with my therapist being a middle-aged woman.
Right.
So.
Yeah. I remember this episode of The Sopranos where Tony, basically tells his therapist, I'm completely in love with you. And she's like, well, I'm everything that you want, right? I'm listening. I'm warm. I'm this mother figure that you never had. And, I'm like, oh, yeah,
there you go.
I get that. Yeah, that's my good juror too.
But Chris, but separate and apart from Mike and I's affinity to middle-aged women,
deeply psychological reasons. Yeah,
empirical jury definitely confirmed that as well. They found in those graphs where it would tier on the one side more favorable and less. So the big things that we were looking for were people over the age of 50. Women were, slightly better than men on the whole, although, older men that weren't, super right wing were still going to be good jurors. And, and then, kind of predictably, young, very, ultra right leaning, men were not going to be our ideals. However, the overall liability was so strong, it probably didn't matter a ton, as far as us winning, given how strong our overall case was. That had more to do with what our, damage ranges were going to be.
So when you guys got, you make a good point, is when you guys are looking at the jury, the demographics aren't really the defining characteristic. They're like, we got this person and this person. This person fits our demographic we want. Let's drop the other one. That's kind of how you were using it. And I think that's, in my experience, the best way it's been. Is that you use it as a tiebreaker, not as a definer of who you want. Is that what you guys did throughout the trial?
That's through voir dire, and when we were going through our strikes and whatnot, I think that's definitely the way that we utilized it. To help us select some of the borderline people. Like, I'm not sure between this one and that one.
Yeah.
So this is fascinating because you guys tried this case during COVID pandemic when you talked about the halo effect with healthcare providers. And I think that halo effect is, always there, maybe heightened now. But I mean, what was that like? Was everyone wearing masks? Were you guys wearing masks? Walk us through what you guys experienced because of this situation.
Greg, set the scene.
We were actually very comfortable. When it comes to social distancing and the big three, Brendan and I are pretty good about that. And we tried to keep ourselves at home as much as we possibly can and away from restaurants and things like that. So, and I say that because I think Brendan and I were both very comfortable the entire trial. Now, of course, we were focused on other things at that point, but yes, the entire courtroom staff, all the jurors, all the members of the jury pool adhere to wearing face masks, adhere to social distancing. And a lot of modifications have been made. Safeguards were introduced in that courtroom to make everybody feel more comfortable as well. The number one, it was a gigantic room. The room itself is essentially designed like a church.
Sure.
It could double as a church if it didn't have a well and a bench and witness stand. And the jury box was essentially expanded upwards with an additional rafter so that there were 3 rows for jurors to sit on, and to the sides as well. So the jurors were really from one wall to the other wall along the entire width of the room. So, and they were all 6 feet apart.
I'm imagining like you're arguing to the Roman Senate almost. It's almost, you've got, this is old school. Yeah, this is like, old school. This is the way things used to be when juries were the hot ticket in town, jury trials.
No, yeah, I think that's very much the design. I mean, they weren't just on one side of the room. They were right there. They were the audience.
I know you guys, this is a podcast, but if I can share my screen, I can show you some pictures that I took of it.
Yeah, absolutely.
I'm disabled, so I don't know if you can enable it. And if not, I can send pictures and you guys can, link it in your show notes or
let's
whatever.
Let's link them in the show notes.
Yeah, because then people could kind of see how it lays out. And I'll give you a couple pictures. One is sort of a closer in, and one is from the way back of the courtroom. But you see, it looks like a church, basically, and behind. I give a lot of credit to the judge and their staff because they really put a lot of thought into this in lead up to it. And they had a kind of a bellwether, if you will, trial, a small criminal trial about a week and a half before ours that was going to be the test of whether they could pull it off or not. And the judge told us, if there's a lot of problems, your trial's not happening. But they did a lot of cool things. So in addition to how Greg described it was, so spread out, the judge said, well, we have to have depth too. We can't just have, because we had 4 alternates, we can't have 16 people in a line across. It just isn't going to work. So there's going to have to be some people staggered behind. But she was worried that the jurors in the back, their view would be blocked if they're flat. So she had personnel build a riser behind the jury box so that there could be sort of like almost, if you think like stadium type seats, like the people in the back were up on an elevated part spread out over top. And that allowed them to be able to see while also being very, very spread out from their fellow jurors. Then they had, plexiglass around the judge's bench. They had plexiglass around the witness box. And after the criminal trial, the judge had found that the jurors in that trial were asking if the witnesses could take their masks off if possible. And so what they did was, because they were in a glass booth, basically, with a microphone, the judge would ask, if you're comfortable, we encourage you to take your mask off, but you don't have to. And so the majority of the witnesses did take their masks off, which I think the jurors wanted to maybe better assess credibility or see the way they were answering. So that's how that worked out. And then all questioning was done from counsel table, and for opening and closing, you could get up to a central podium with a microphone just for that part to stand and present if you chose. But I actually kind of liked sitting. I thought I wouldn't like sitting at counsel table to ask questions. I actually really liked it a lot. I thought it was preferable.
So that's interesting. Did you think that you would like sitting? Because I have this thing in my head where it's, if I have to sit, then I'm going to start going crazy because I pace a lot. And so was that a factor for you?
So going in, I was like, I'm going to hate sitting at the table asking questions, because, I'm the same way. Like I move around and I, gesticulate a lot. And in hindsight, I love it because, we're about to get booted again.
Are we really?
Unlimited, I think it said unlimited.
It says we're unlimited. Yeah.
Oh, look at that. There we go.
Now we're rocking and rolling.
We're free.
We can go another 3 hours now.
Yeah.
But anyway, I liked it, and I'd be curious what Greg thought comparatively. But I liked it because I could literally have my exam notes right there on the table, and we just got lucky that our counsel table was right next to the witness box. So Greg and I were like, maybe 9 feet from the witness, whereas defense counsel was like on the other side of this like cavernous courtroom, and he was stuck having to ask his questions from way over there. I don't even know how he could even see the witness half the time.
Sure.
But Greg, what did you think of the sitting and asking versus our normal standing in different places?
I really liked it too. And I think a big part of it as well is that, number one, like you said, we were like 9 feet from the witness. So every witness was like our witness. Even when the other attorney, the defense attorney, was asking his witness questions, the witness would look to us to give us the answers. So that was great. But the fear that I had going in was that with a mask on the whole time, it would be hard for people to understand us. It would be hard for the witness to understand us. Everything would seem muffled. Well, I didn't consider that we would have microphones, which I'm sure most courtrooms already have. But these microphones were pretty high grade, pretty new, because the whole courtroom had just been renovated maybe in a year or two before our trial. So sitting at a counsel table with that microphone, right by our face masks, and being in this cavernous courtroom designed like a church, I mean, our voices boomed throughout that courtroom.
Great.
There was no way, as long as we spoke into the microphone clearly, that we couldn't be understood. So having our lips covered really wasn't a big deal at all. My fear was unfounded.
Well, what about when you guys were whispering back and forth?
Oh, yeah, that's a good point.
No. I mean, how did you handle? Because a lot of people whisper, hey, let me whisper this or that. And did you? I mean, that's not going to work with your mask, did it?
But it did, though. I feel like I could still whisper with my mask on, and otherwise we would just write notes back and forth to each other if we had stuff. So,
okay.
What I think this is fascinating too, because I can give myself any number of reasons for why I shouldn't try a case, right? And one of them is we're in the middle of a pandemic. No one wants to be in there. But listening to you guys today, it sounds like, hey, these folks were in there to do justice, and they were in there to listen to the case and give their full attention to the case. And it sounds like they did justice for you guys.
Big time. And I did not get any sense that the jurors, and a couple of them, tried to get off, but no different than most jurors try to get off. It wasn't pandemic focused. And I thought that once they were there and they realized what the case was, these people were happy to be there, and it didn't necessarily feel like a punishment to them. The other thing is, I think a lot of people have like apprehension about, just the logistics and what's it going to be like trying a case with a mask on all day, and isn't that going to mess me up or be, the fact of the matter is, we've all tried cases, and as soon as you get in there and the judge says, call your first witness, or, do you want to give your opening statement, you forget about all that like peripheral stuff. And Greg and I completely forgot that we had masks on. We would drive, back to the hotel, and Greg would still have his mask on because you like forgot about it.
That's awesome.
It just became like part of you. So I just think that so many of those you have to think through the logistical stuff of, making sure that the spread out jury can see and hear appropriately. But as far as, people dealing with, what's it going to be like trying a socially distanced or masked up case, it's no different than if you go and try a case in front of a new judge or new courtroom and just having to figure out the, idiosyncrasies or different setup of a courtroom in those places is the way I thought about it.
And awesome. In fact, Brennan mentioned this to me. There are certain times where, you just can't keep your poker face. If a witness says something that puts a smile on your face, or that's going to be really bad for their side, the jury doesn't see you smiling.
Yeah, that's nice. That's not. That is a good thing.
Yeah, or me mouthing, "Give me a break."
But what the F is not?
Yeah, exactly. Totally. And there were some of those moments where I was glad I was covered up.
Yeah. Actually, that makes a lot of sense because I do. I wear a lot on my face.
Yeah, me too. I'm the same way.
Well, is there anything that you guys wanted to discuss that we didn't cover, and about the trial, about your practice, or anything that you think people should know?
I just, I can't give enough credit to the court. Judge Jackie Bernard, who presided over it, her clerk, Vicki Wirtz, and, the staff, the sheriff, all of these people that made this trial go off seamlessly. There was not a single hiccup in this whole trial as far as how it was run. And it was done safely. And I think everybody felt safe, and the court, just really did a wonderful job of, stressing the importance that, even though we're in the middle of this pandemic, this whole process is so important. It's so important that you're here. And I can't give enough credit to them to, be willing to try to get cases going and trying to figure out ways to try some cases. Maybe you can't do it at the volume you were doing before, but it really, in my mind, starts with that belief system and work ethic of the people that are running the court. And Judge Bernard and everybody supporting her in the Blair County court system were unbelievable, in my opinion. And the trial only went off. And I think about how lucky we were and how lucky our family was in that we got to try this case rather than just get it kicked, indefinitely down the road, because it was an important case and this family really needed help. And, but for the court being willing to figure out ways to make it happen, they wouldn't have gotten their day in court for a very, very long time. So I just can't say enough. And I hope other court systems around the country, reach out to other courts like Blair County and Judge Bernard to get ideas for how they made this happen successfully, to get ideas to get their own court systems up and running again. And now, just before I step off my soapbox here, these courts that are just kicking it down and, like we're just going to kick trials down until the fall and basically hope for something to happen or something to change by then. As John Morgan says, hope is not a plan. And you have to start figuring out ways to try some cases now than just expecting that things are going to suddenly be different, 6 months from now, because they might not be. And then what? Then you just wasted 6 months, basically, is my thinking of it. So, and that may be a bit simplistic, but so that's all I have to say on it.
Yep, absolutely. Well, guys, hey, I appreciate you guys coming on today and talking about this trial. Hey, congratulations to both of you, and also just thanks for going in there and swinging away and doing what we're supposed to do, which is try cases and carrying that forward. And your client is obviously very lucky to have two excellent attorneys like you guys.
Thank you. It was really great to talk to you guys. It was nice to meet you and talk to you.
Yeah, I love talking with real trial lawyers. This was awesome. Thank you guys so much for inviting us to do this. It was great.
Got it.
Thanks, fellas.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Man, those guys are great, right?
That's like, you forget you're kind of on the show and we're talking about this, because talking to them about the things that they're doing and things that we also have experience with, that I think a ton of other trial lawyers have experience with, and getting their input, how they applied it. I mean, that was we could have talked probably the whole day. Easily.
So that's the thing is, and that's one of the reasons why I wanted to do this podcast, because I know we can just get really granular on about every topic. Yep. And then, so at the same time, I'm watching the time and I'm thinking about people listening and short attention spans. And it's ironic we're talking about, limiting the amount of a time at a trial and trying to do that here. Right.
Well, yeah. Okay. As he was going, like I was putting down the list of questions, they would say something would come up, and I didn't even get to talk to them about evidentiary issues. Like, did audit trails come? Because they had.
That's what I was going to ask about, audit trails. Yeah, sure.
The change in the records didn't match up, and then they did. And then they said they went to the scene. I was like, was that pre-suit? Was that agreed upon? Was that the site inspection? How did you record that? There were so many other questions, and then. Did they submit records at trial? That we didn't even get into really the evidence exhibits, but there was so much other stuff. It was really.
So, and that's an interesting thing that you do. And you know what? We may just have them back on the show and then start digging into that stuff. And we're going to link all of the things we discussed in the show notes. And then we're also going to put their contact information in there as well. So if anyone has questions, they can reach out to them.
I'm looking forward to watching it or reading his closing.
Absolutely.
It's going to be interesting. But we talked more about like strategy, I guess, kind of not, we did a little of how did this actually go off and what exhibits, all that kind of stuff. But we could have gone for easily the whole day.
Yeah. So, kind of some news for me. I partnered up with Tad Thomas, and I was having an issue with my Zoom, and then I got a notification that I got upgraded to the premium status on the Zoom, and that had happened
already.
And right. It is just things, the perks are already here. And so it literally cut us off somehow, some way. And, Brennan made the great point that, oh, this is just like trial, you got tech that goes bad. So sorry for anyone listening at home if it's a little choppy in the middle, but I don't know how this technology works. I just know that it somewhat worked.
Yeah, it was awesome. Glad I could be on for it. Really appreciate it.
I appreciate you jumping on, Chris. You got anything exciting coming up?
No, we're just getting through it. I think trying to get people moving, on cases is really the thing now. It's harder to get in front of those judges and really relay what's going on. So that's where I'm at, is trying to push things, because here we just had a hearing yesterday. They said probably March is the next time we'll get a trial, and seeing that it's now September, that's a little disconcerting, but oh well.
Yep. And you and I have a case that we just got a trial setting in March as well, I think, too.
Yeah, so, that's true. Yeah. And hopefully we get this one in November, and we'll let everybody know how it goes. We're going to push.
Exactly right.
A lot of ideas they shared with us that we're going to try and impart to the court. So it should be fun.
Yeah. And I'll say it again. All their contact information is going to be in the show notes, the transcript, and then the pictures of the courtroom. If you're thinking, I need to get this case in, but I need to talk with the judge about the logistics, these guys are going to kind of walk you through that and get you into contact with a court out there that's doing these cases.
Yeah. Awesome. So, see you guys.
See ya.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.